It's just past 11 o'clock. My name is Philip Coppel. I'm Queen's Counsel at Cornerstone Barristers. First of all, the webinar is going to be recorded. It will be posted up on the Cornerstone website if you want to have access to it. At the end of this morning, I will leave 10 or so minutes for questions using, you can use the Q&A facility on your screen. And I have also received a number of questions already, which if they aren't answered by my talk itself, I'll try and address in the time remaining. Now, I'm going to start with a quick introduction to the current data protection regime in the UK. And I do this for a reason. It's partly prompted by those questions that have been posted, or at least some of them, for the seminar. And for those of you for whom this is familiar, forgive me. For those of you for whom it's not so familiar, it's important to an understanding of the penalty regime. Let me find my slide. So on the 25th of May 2018, what I term regime change took place in the UK in relation to data protection. For the preceding 20 or so years, data protection in the UK had been governed by the Data Protection Act 1998. And that act, that act was a domestic implementation of an EU directive, that's Directive 96/45/EC. The European Parliament had formally adopted the directive in October 1995 as an internal market harmonisation measure, and that's important to understand. Being a directive, it allowed national legislatures a certain latitude in the manner of implementation, as directives do. The 1998 Act sought to cover the field so far as data protection was concerned, wrapping up all sorts of data protection and data processing by all sorts of bodies, including law enforcement and the security services. The power to impose civil monetary penalties up to £500,000 was only introduced to the 1998 Act in 2008. We see the provision there. Until the sunset years of the 1998 Act, so in the period, in the years leading up to 2018, there were remarkably few civil penalties imposed. The regulator, the Information Commissioner, up until then saw its principal role as explanatory and educational. And to get a measure of regulator disinterest in penalties, reference may be made to the Leveson report into the press, or the activities of the press. And one of Lord Justice Leveson's key recommendations was that the Information Commissioner's Office should take immediate steps to prepare, adopt and publish a policy on the exercise of its formal regulatory functions in order to ensure that the press, with which he was concerned, complies with legal requirements of the data protection regime. He obviously was concerned with the press, but it's not so confined. To be fair to the Commissioner, the relationship between data processing and the press has been and remains a difficult one, indeed at sometimes a tense one. In the decades following the enactment of the 1998 Act, data processing capabilities, of course, expanded, some might say exploded. Notions of personal privacy evolved, and ideas of the legitimate legislative competence of EU bodies became more divergent. It would be wrong to think that all of the impetus for privacy protection and data protection came from the EU bodies. At a domestic level, in a matter of years, the Judicial Committee of the House of Lords performed a somersault. Thus, in 2003, in this judgment we see on screen, Lord Hoffman, giving the lead speech in Wainwright and the Home Office, declared, quote, "I would reject the invitation that since at the latest 1950, there has been a previously unknown tort of invasion of privacy." Within a decade, that same body, the Judicial Committee of the House of Lords, was proclaiming a previously unknown tort of misuse of private information. And let's find the next one. We see it in Campbell and Mirror newspapers. conjoined at birth with commercial confidentiality, a successful operation in its early years saw that tort separated from its equitable twin and develop a life of its own, and a healthy life at that. Into this waded various interested bodies. The EU, for example, introduced a Charter of Fundamental Rights, and Article 7 of that charter provided that everyone had the right to respect for his or her private and family life, home and communications. Then we see Article 8 was even more pointed. It described a separate right to the protection of personal data concerning him or her. Next, in December 2007, the Treaty of Lisbon was signed, coming into effect on the 1st of December 2009. One of the things that it did was to introduce an article guaranteeing everyone the right to the protection of personal data concerning them, and that's Article 16 of the TFEU. It directed the European Parliament and Council to lay down the rules relating to data protection. And so with that, the marching orders were given for what became the GDPR. During this time, the Council of Europe was not idle. It had been responsible right at the beginning for the 1981 Data Protection Convention, called Convention 108. That convention, Convention 108, had spawned the Data Protection Act 1984, a purely domestic piece of legislation. A work, some might say, of refreshing brevity. It did little to protect, in practice, personal data. Anyway, in 2011, the Council of Europe began work on modernising Convention 108, which was eventually adopted in May 2018. On top of this, there was the EU's Law Enforcement Directive. While the GDPR lays down general rules to protect individuals in relation to the processing of their personal data and to ensure free movement of personal data within the EU, the Law Enforcement Directive lays down specific rules for data protection in the fields of judicial cooperation, in criminal matters, as well as police cooperation. Now, in all of these instruments, we can discern a drive to increase individuals' data protection rights, and importantly, an increased and more muscular role for the regulator. And in no small part, the regulator could flex that increased muscle mass through the imposition of monetary penalties. And that was generally, has been generally welcomed and indeed rarely questioned. All of this culminated on the 25th of May 2018 when the GDPR took effect. Side by side with the GDPR and taking effect on the same day was the Data Protection Act 2018. What then is the resulting architecture of the regime? I'll call it the interim regime. I give it that name because the UK, of course, departed from the EU on the 31st of December 2020, and that resulted in some changes, which I'll come to. They haven't been as those changes haven't been as monumental as those of the 25th of May 2018. You'll remember that I've just described the 1998 Act as covering the field in relation to data protection. The interim regime did the same, but it's important to see how the GDPR dovetails into the 2018 Act. Under the interim regime, the processing of personal data in the UK was divided into 4 separate categories, and those categories remain. First, we have intelligence services processing of personal data. This sector was and remains governed by Part 4 of the DPA, that's sections 82 to 108. The GDPR has no role and had no role in that processing. It had no role, not least because the EU has no legislative competence. Secondly, processing of personal data by competent authorities for law enforcement purposes. This was, and indeed remains, governed by Part 3 of the DPA, that's sections 29 to 81. Part 3 of the DPA implements the Law Enforcement Directive in the UK. Again, the GDPR has no role to play. Just next slide. You can see the architecture there on the opening page of the DPA. Processing of personal data that's not within the first 2 categories, so it's not intelligence processing, not law enforcement processing, was and remains what is called general processing. and it comprises the bulk, if not all, of the processing with which most of you, if not all of you, will be concerned. There are two separate sectors dealing with general processing. First, processing of personal data that does fall within the GDPR. What the 2018 Act did was to, in its own words, supplement the GDPR. And we see that right at the beginning of the Act, highlighted there. And how it did that is spelled out in sections 4 to 20 of the DPA, and importantly, the various schedules that those provisions bring in. Secondly, the general processing of personal data that falls outside the GDPR. Here, by definition, of course, GDPR has no direct role because it was data processing that was outside EU competence. The 2018 Act nonetheless applies the GDPR, but with modifications that are set out in sections 21 to 28 of the Act. Now, for convenience, when I talk of general processing, I mean both kinds of general processing. The differences are, for present purposes, not important. And as I said, most processing of personal data within the UK is general processing. Now, pausing here, it may be wondered why it was necessary for domestic legislation to supplement an EU regulation. After all, whereas a directive by definition requires domestic enactment to implement it, a regulation has direct effect. The answer to that lies in the terms of the GDPR. Although described as a regulation, it has elements of a directive in it. Specifically, the GDPR provided a significant measure of legislative latitude in prescribed areas. And you can see that, for example, right at the beginning of the first directive and the Article 23 restrictions. And that, first and foremost, is given effect to by the early schedules in the DPA. Now we get to 2020, and with the UK's departure from the EU at the end of that year, the GDPR was converted into domestic legislation. And this was done by delegated legislation, and it's now called, if you look at the updated version of the 2018 Act, it's now called the UK GDPR, and the GDPR simpliciter, what was before, is now called the EU GDPR. The UK GDPR is basically the same as the EU GDPR, but with various provisions shorn off it, a few changes here and there, pounds rather than euros and so forth. But the fundamentals are exactly as they were before the 31st of December 2020. Same time, a few changes were made to the DPA 2018, so that the fingers of the dovetail still fit into the slots. It's not easy always to see what's what in the current regime, but there is a document which you can search for on the internet called a Keeling schedule, which shows what's been struck out of the GDPR and what's been added into the UK GDPR so as to make up the UK GDPR. Importantly, for present purposes, there have been changes to Article 83 dealing with administrative fines, also known as civil penalties. But the basic architecture for general processing remains as it was when introduced on the 25th of May 2018. Thus, onto controllers are imposed a series of continuing obligations for as long as they are processing personal data. The main obligation is, of course, the accountability obligation, which has behind it 6 principles for which the controller is responsible and must be able to demonstrate. There are also structural obligations relating to setup, internal organisation of a controller, systems, record keeping, impact assessments, and so forth. Quite separate from the continuing obligations are the obligations that are triggered by a data subject exercising a right conferred, that's Article 83, by the GDPR. For example, the right of access conferred by Article 15, the right to rectification conferred by Article 16, the right to erasure, Article 17, right to restrict processing, Article 18, right to object, Article 21. The distinction between the continuing obligations and the obligations that are triggered by a data subject exercising a right, usually by the subject giving the controller a notice, is important to the question of penalties. Put very generally, non-compliance with continuing obligations opens the door to regulatory enforcement by the Information Commissioner. It does not give a right to a private individual directly claiming compensation from a controller. On the other hand, non-compliance with an obligation arising from a data subject having exercised a right gives rise to a private law claim by the data subject, which is normally brought in the county court or the high court, but it can also found a penalty notice. So that's my general overview. The precise position is more nuanced than that, and that leads me really to the focus of this webinar, which is civil penalties under the DP regime. By way of introductory remark, I would note that civil penalties may be issued not just for contraventions of general processing, but also in an abbreviated way, contraventions of the law enforcement data processing regime. That's the one covered by Part 3 of the DPA, and of the Intelligence Services Data Protection Regime. That's the one covered by Part 4 of the DPA. I describe it as applying in an abbreviated way because the power to impose civil penalties doesn't cover non-compliance with continuing obligations. It only covers, in those cases, a situation where the controller has not complied with a right that's been conferred on and invoked by the data subject, complaint's been made to the Information Commissioner, the Commissioner has issued an enforcement notice against the controller, and the controller has not complied. So quite a few hurdles to be jumped before there's any possibility of a civil penalty in those two regimes. That's the Part 3 and the Part 4 regime. Having got that observation out of the way, I want to concentrate on what's more concern to most controllers most of the time. That is civil penalties arising out of general processing. And here, at the heart of the civil penalty regime is the penalty notice. And the Information Commissioner may give a penalty notice to a controller and to a processor. In addition, where a person is neither the controller or processor of personal data has been given an information notice, the Commissioner may also give a penalty notice to such a person, even though not a controller or processor. Let me find where I am on my. So we see that there in section 149. And we see how it's brought in. You see the reference there to enforcement notices. Then when you get to penalty notices in section 155, the Commissioner is satisfied that a person has failed or is failing as described in those provisions, hasn't complied with notice. Commissioner may, by written notice, require the person to pay the Commissioner an amount in sterling specified in the notice. Then prior to giving a penalty notice, the Commissioner may have foreshadowed the penalty notice by giving the controller or processor, as we've just seen, an information notice, assessment notice, or enforcement notice. But that isn't essential, nor, it would seem, is it the norm. Where the Commissioner is satisfied that the controller or processor has failed or is failing to comply with any of the continuing obligations or a data subject's right, the Commissioner may give a penalty notice without having given any of the other types of notice. The only penalty is a monetary one. That's the only one. Of course, in the criminal sphere, penalties may be either monetary or they may involve incarceration. This then leads me to what is the real question in relation to the monetary penalty regime. What is the nature of a penalty under the DPA? Is it really a civil penalty, no different in kind to those issued by, say, a parking inspector? Or is it in the nature of a fine of the kind that might be imposed by a magistrate's court for contravention of a criminal offence? Or, on the other hand, is it something in between, combining features of each? Now, the conventional view is that being a civil penalty issued by a regulatory body, it has all the attributes which we would ordinarily associate with a civil penalty, whether issued by a parking inspector or otherwise. Thus, the regulator parking inspector, information commissioner, issues it if satisfied on a balance of probabilities that there has been a contravention. The penalty stands unless the recipient appeals against it. If the recipient does appeal, it is for the recipient to demonstrate that the penalty should not have been imposed or that it's excessive in amount. There's no burden of proof on the regulator. Now, one can understand such a regime for parking enforcement where the penalty is for a known, in London, £80 for contravention, reduced by 50% if paid within 14 days. This is more difficult to understand, let alone defend, where the commissioner can impose an administrative fine now up to £17.5 million, or in the case of an undertaking, read a company or business, up to 4% of the total worldwide annual turnover of the preceding financial year, whichever is the higher. And that's Article 83(6) of the UK GDPR. A penalty at this level, needless to say, would be sufficient to cause most businesses to fold, of course, taking with them the jobs of all those that work there and the investments made by many. This distinction between a civil penalty and a criminal penalty and what goes with it is more than mere nomenclature. While the general procedural protections of Article 6 of the ECHR as implemented by Human Rights Act will apply to the regime, whatever it might be, the more specific procedural safeguards provided in Article 6.2, presumption of innocence, and Article 6.3, procedural matters, only come into play if what we are looking at is better described by the epithet criminal rather than civil. This conundrum is not unique to the data protection regime. The issue is one that has been considered in other regulatory spheres. What the data protection regime does do is to put the issue into sharp relief. It does this principally because of the level of penalties, the manner in which they are imposed, and so forth. As I've said, the view taken in the first 4 years since May 2018 of the new regime is that these are civil penalties, and it's up to the body that has been given a penalty notice to appeal against it and to demonstrate that it should not have been imposed, or if it has been imposed, that it should be for a lower level. I would suggest that this conventional understanding needs closer examination. And it's not something which should be acceded to unquestioningly. The domestic classification, that is to say, when legislature has said this is a civil penalty or this is a criminal penalty, is not the end of the matter. And I say this for a number of reasons. First, which I've already adverted to, the maximum penalty or the maximum amount of penalty marks it out as a punitive regime. We see that in Article 183 of the GDPR, which we've already looked at, and Section 157 of the Act. ECHR jurisprudence tells us that the determinative issue is the potential penalty that may be imposed, not the actual penalty imposed. And that's one of the very first cases from the European Court of Human Rights, England, Netherlands. In any event, the maximum penalties permitted by the DPA and the GDPR are not theoretical, they're real. In the 4 years since the coming into force of the DPA regime, or the new regime, the ICO has already issued numerous notices of intent to impose monetary penalties against the individual controllers for tens of millions of pounds, and in one case for in excess of £100 million, sufficient to end those businesses and lest it be thought of no consequence, the livelihoods of their employees. So that's my first point. Second point is the immediate concern of monetary penalty is punitive. It's not simply concerned with encouraging a person to take steps to comply, whether on this occasion or on future occasions. And we can see that articulated in the matters that must be taken into account in setting the penalty under Article 83(2) and Section 155(3), which we see up on screen. And it's for this very reason of punishment that a monetary penalty may be given under the DPA where the person to whom it is addressed has not complied with a notice, an enforcement notice addressed to that person. In other words, a penalty can be on top of an enforcement notice, for example. And in this way, the penalty under the DPA is indistinguishable in outcome from the imposition of a fine for non-compliance with, to take an example, enforcement notices in other regulatory regimes, for example, the town and country planning regime. And both of these are undeniably penal sanctions imposed at the end of a criminal process. The third point is that the quantum of the monetary penalty, how much it's going to be, is set by reference to criteria that mimic the criteria applied by criminal courts on conviction for offences. And that's borne out when one compares this provision in front of us, section 155, 2 and 3, to the Sentencing Act 2020 and the sentencing guidelines which have been issued by the Sentencing Council for various regulatory offences. Unlike other monetary penalty regimes, for example, tax penalties, the penalty is not set arithmetically by reference to the saving made from non-compliance, nor to disgorge a benefit secured from non-compliance. My fourth point is that the imposition of a monetary penalty for non-compliance does not affect the right of the data subject to compensation for material or non-material damage resulting from the non-compliance. The entitlement of a data subject to compensation is a civil consequence of a controller's non-compliance, leaving the imposition of a monetary penalty as a purely punitive sanction. We can also see, for example, that the penalty is paid into consolidated revenue, which is usual for a criminal penalty. It's not being used to defray the administrative cost of enforcement. As one further point in this regard, the imposition of a civil penalty is generally a private matter. Thus, for example, civil penalties for late tax return, self-assessment, are not matters that go beyond HMRC and the defaulting taxpayer. The imposition of a criminal fine takes place at the end of a public process in court with a formal record of the outcome. Now here, the Information Commissioner makes it very public, the imposition of civil penalties under the DPA. And again, it's another marker that it bears the attributes of a criminal regime. And I would suggest that the procedural construct of an administrative fine does not transubstantiate the essential nature of the imposition of a monetary penalty under the DPA into something other than a penal sanction. It is this essential nature, that of a penal sanction, that motivates the protections to which the common law defaults. Namely, before imposing the sanction, the burden rests on the party seeking the penal sanction to prove the elements under the law that gave rise to it and to prove those elements beyond reasonable doubt. Of course, it's open for Parliament to displace either of both of those protections, but if it wishes to do so, it must do so by unmistakably clear language. As I say, this is an issue, it's an important issue that will have to be grappled with at some stage. For the moment, let's assume that it all stands as the Commissioner would wish. Section 160 of there's the maximum penalty. Section 160 of the DPA requires the Commissioner to produce and publish guidance about how the Commissioner proposes to exercise the Commissioner's functions in connection with, amongst other things, penalty notice. This includes spelling out the circumstances in which the Commissioner will consider it appropriate to issue a penalty notice, the appropriate circumstances for oral representations, and how the Commissioner is going to determine the amount of penalties. And the Commissioner has done this now with a document that was published at the back end of 2018 called Regulatory Action Policy. You see the cover sheet there, of which pages, available on the internet, of course, pages 23 to 26 are the most relevant so far as penalties are concerned. The Commissioner's stated aim in applying penalty notices is to, quote, ensure compliance with legislation and information rights obligations, and states this in the policy. To do this, penalties must provide an appropriate sanction for any breach of information rights or legislation, as well as act as an effective deterrent. Now, as to the circumstances in which a penalty notice will be appropriate, we see the guidance states that in the majority of cases, we, the ICO, will reserve our powers for the most serious cases representing the most serious breaches of information rights obligations. These will typically involve willful, deliberate or negligent acts or repeated breaches of information rights obligations causing harm or damage to individuals. So two elements, the sort of deliberateness and resultant harm. In considering the degree of harm or damage, we may consider that where there is a lower level of impact across a large number of individuals, the totality of that damage or harm may be substantial or require a sanction. So you've got data security breach involving 1 million people, minor to each of those million, you add them all up and cumulatively it's no longer minor. This means that each case will be assessed objectively on its own merits, usual stuff. The guidance says that the commissioner has a hierarchy and adopts a risk-based approach, looking at the number of individuals affected, picking up that last point, the degree of damage or harm, the sensitivity of the information involved, really the same thing, repetition of contravention, willfulness, and so forth. And these criteria, these same criteria, also inform the quantum of the penalty. The procedure then, before giving a penalty notice, the Information Commissioner must, by written notice, give a person a notice of intent, informing that person that the Commissioner intends to give a penalty notice. It's got to be given not less than 21 days and not more than 6 months before the penalty notice is given. The notice of intent must contain a statement of the reasons why the Commissioner proposes to give a penalty notice, including a description of the circumstances of the failure to comply with continuing obligations or a data subject right. It's got to also include an indication of the amount of penalty that the Commissioner proposes to impose, including any aggravating or mitigating factors that the Commissioner proposes to take into account. Having got a notice of intent, it's obviously important and sensible for the recipient to consider it closely and to make representations wherever possible. Quite possible that the representations will involve technical matters, particularly where the issue is a data security breach that has come from outside. In those situations, it's possible for the recipient, indeed very often sensible for a recipient, to engage outside technical expertise to prepare supporting expert reports. The Information Commissioner may not give a penalty notice before the end of the period specified in the notice of intent for making representations. And in deciding whether to give a penalty notice and in determining the amount of the penalty, the Commissioner has to consider those representations that have been made. And the guidance states that regard can also be had to representations that have been made by other data regulators, and that in the case of penalties over £1 million, a board may be convened by the Information Commissioner to consider the matter. Having got all of that, when deciding whether to give a penalty notice and the amount of the penalty, the Commissioner has to ensure in each case that the penalty is effective, proportionate and dissuasive, and must have regard to those matters that we've just seen in section 155 of the DPA. The policy document, that's the regulatory action policy that we've just been looking at, sets out, this is on page 27 of that document, a 5-step approach that the Commissioner should follow, or says will follow, in setting a penalty. So first of all, we see step one, the Commissioner sets an what's termed initial element that doesn't include any financial gain from the breach, so just a raw initial element. Step two, the Commissioner adds in an element to censure the breach based on its scale and severity, taking into account the considerations that we've just seen in section 155 of the DPA. Next, step three, the Commissioner adds in an element to reflect any aggravating factors. So that's willfulness, repetitiveness, negligence, if you like. Then step four, the Commissioner adds in an element for deterrent effect to others. And then finally, the Commissioner reduces the amount to reflect any mitigating factors, including the ability to pay. In short, we look at this and we see there are more additions than there are reductions. Penalties got to be paid to the Commissioner within the period specified in the penalty notice, which must be not less than 28 days from the date upon which the notice is given. If the recipient doesn't pay within the specified time, it hasn't appealed, the penalty can be enforced as if the penalty notice were a court order. In short, the recipient doesn't want to be there. If the recipient doesn't like the penalty, an appeal really ought to be lodged. And that then takes me to the right of appeal. The right of appeal against a penalty notice is to the first tier tribunal, general regulatory section. I've already touched on the nature of the appeal, i.e. that it's currently thought that the recipient of the penalty notice bears some sort of administrative burden of establishing that the Commissioner should not have issued the notice, or that it is excessive in amount. This is just, despite such an appeal being variously described as a full merits review or a de novo hearing. And this is an important matter. It's an important matter because the tribunal, and in particular the recipient of the penalty notice, is something of a disadvantage to the Information Commissioner. And the position is yet worse, I would suggest, than a mere reversal of the burden of proof and a lowering of the criminal standard, as might be suggested. What has happened is that, relying on a throwaway line in a Court of Appeal judgment, the line that has been taken and is increasingly taken in the tribunal on appeals from the Information Commissioner is that the Information Commissioner is the expert regulator, and so a tribunal should not lightly interfere with the regulator's judgment. It's not the sort of argument that would commend itself in a criminal court to support, say, a police prosecution. But what is relied on for this proposition, increasingly relied on if you look at tribunal judgments or decisions on appeal from the Information Commission, is a judgment of the Court of Appeal in the Crown Hope and Glory Public House in Westminster Magistrates Court of 2011. Now that judgment, there it is there, was concerned with section 181 of the Licensing Act in Schedule 5, which provide for appeals to a magistrate's court from certain decisions of a licensing authority under that act. It wasn't concerned with the imposition of penalties. It was concerned with whether and on what conditions a business should be permitted to carry out particular licensed activity, the sale and supply of alcohol, the provision of entertainment and late night refreshment from premises in Soho in London. And in its judgment, the Court of Appeal reviewed the background to the enactment of the 2003 Licensing Act and its structure, and central to its reasoning was the licensing system focused on local needs and concerns, which was a judgment call for the licensing authority, i.e. the licensing committee of the local council, which was best placed to make it and to be accountable for it. And so it was that the Court of Appeal stated in its conclusion, which we can see in those paragraphs there. The licensing function of the licensing authority is an administrative function, correct. By contrast, the functions of a district judge is a judicial function, correct. Licensing authority has a duty in accordance with the rule of law to behave fairly in decision-making procedure, but the decision itself is not a judicial or quasi-judicial act. It's the exercise of a power delegated by the people as a whole to decide what the public interest requires. You see that in paragraph 41. It is that, which is elaborated on later on in the judgment, which drove the Court of Appeal's conclusion in that judgment. It is normal for an appellant to have the responsibility of persuading the court, read here, first tier tribunal, as it's been imported, that it should reverse the order under appeal. The magistrate's court rules, read the first tier tribunal rules, envisage that this is so in the case of statutory appeals to magistrate's court from decisions of local authorities. Now, as I say, unfortunately, this has been taken to amount to a statement of wider principle applicable to appeals to the first tier tribunal from decisions of the Information Commissioner, including penalty notices. And in support of this, sometimes reference is made to a Supreme Court decision called Hashem and Ali of 2016. Now, I draw this to your attention because it is a proposition, as I've said, that is gaining traction in the first tier tribunal, repeated without analysis. And for those on the receiving end of a penalty notice, already weighed down by a criminal sanction, reversal of the burden of proof, and none of the protections that ordinarily attend the criminal process, it is the last thing that they need to encounter. Now, I end, before getting to your questions, with a confession. There is next month an appeal in the upper tribunal in which the issues that I have raised, reversal of the burden of proof, hope and glory, and so forth, will fall to be considered. I appear for one of the parties, for which side I will leave you to guess. So that's all that I wanted to say. I have, as I have said, received some questions that have been, some of which have been covered in my talk. And let me have a look. I think there's some in the Q&A. And some in the chat room. Someone says I've chopped off some of the slides. I'll try and fix that. Okay. Okay, so I can forget about that. Question one is there a limitation period for penalties, civil penalties? And if so, are there different limitation periods for criminal and civil penalties? The answer is I don't think there is a limitation period for the imposition of civil penalties. It may be harder to sustain a civil penalty if the regulator sits on the regulator's hands for a long period of time, and then turns round and says that one is to be imposed. And I say that because you remember when we were looking at the criteria for the imposition of a penalty and the setting of a penalty, one of the elements put in there was dissuasiveness. And that dissuasiveness, of course, ebbs away with the passage of time between what is complained of and the imposition of a penalty. Another question that is asked of me is when it is appropriate to bring a civil claim as opposed to attempting to gain resolution via the ICO. And the point here is that a civil claim, that is to say by a disgruntled data subject, they're not limited to a data subject, is a different thing from a penalty. Civil claims, as I've said, are brought in through the county court or the high court, whereas the regulatory regime, that the penalties are initiated by the regulator, the Information Commissioner, and then trundle their way through the tribunal system, first tier tribunal, upper tribunal, and so on and so forth. I mentioned there, just as a matter of interest, that civil remedies are not limited to the data subject. It's not often appreciated. And how this can arise is if, for example, a data subject's rights are breached, let's say by a security breach, that affects a third party, let's say a bank of the data subject, and the third party is the one that bears the financial cost because they have to pay people who engaged in a security breach. And if that results from another party's, the controller's default, then you can see why there might be a claim being brought against the first controller that allowed that to happen. Next question, which has been asked of me, is potential changes in light of proposed UK reforms. Well, that's very topical. You may have heard in the recent Queen's speech, the government proposes to purely domesticate the data protection regime in the United Kingdom, with the prospect of having a bonfire of regulation and what have you. Exactly where that's going to go, nobody knows. What I think can be said, partly because this country is not simply a signatory, it's one of the principal drivers for Convention 108 right back more than 40 years ago, the modernised version, which it ratified in no time, and what have you, is that the basic principles that we see there, which are articulated in the GDPR, are going to stay with us. They're not going to vanish. It might be that general processing, instead of involving an amalgam of looking at a now UK GDPR plus the DPA Part 2 and the various schedules, will be brought all together. But I would be very surprised, very, very surprised, if the basic elements of the continuing obligations on controllers and the rights that are conferred on data subjects were materially different from what we now see. It might be simply, in a sense, an encyclopedic Data Protection Act, rather than having to look at two matters together. Then I've got sorry, some of these questions have a question. I think that covers. Oh yes, somebody has asked me about the tort of misuse of information, and particular statements which have recently been made in judgments, very recent judgments of the High Court, that it has to have a level of seriousness before the tort is involved. Now, this doesn't involve the regulatory regime. This involves, as I mentioned right at the beginning, a freestanding tort, which the courts have invented, of misuse of private information. Now, very often that misuse of private information will also involve a contravention of the data protection regime. They're not entirely coincident. The tort is more concerned with what might be termed personal private information rather than financial information, and a misuse of that, in a sense, a willful misuse of that information rather than, for example, data security breaches and what have you. And it's quite right that the courts are very concerned to close off what appears to be a growing industry of claims being brought against data controllers and individuals for misuse of private information, which are quite tiny, really, in their own terms, with the claimants maintaining that they've suffered no end of grief. Now, sometimes these are brought collectively, and of course you'll be aware of the Google litigation. Sometimes they're brought not as representative actions, sometimes as group litigation, sometimes as hundreds of claimants, each claiming. But the one-off individuals who've decided to kick off proceedings, very often in the High Court, despite small amounts, look as if they're going to be curtailed by the various judgments to which reference is made. I think Underwood and Bounty of this year is one of them. So that's what I'd say in relation to that. And then, sorry, I've got one final question that was on my sheet. That is, what are the penalties that the ICO is likely to impose on a council where the council has processed data in a way which they believe was permitted under the regulations, even if technically in breach? Now, you will have seen from the criteria that I've given that that sort of thing is unlikely to result in a penalty by the ICO. In imposing penalties, the ICO has shown a much greater willingness to do so on private organisations rather than public organisations. But even in the private sphere, the penalties are generally only imposed, financial penalties are generally only imposed where there has been not just a technical breach, but there's been a real breach, a certain willfulness, deliberateness, or negligence on the part of the body concerned, resulted in real harm, whether to an individual or the amalgamation of individuals, albeit on a smaller scale. Then I've got another question that comes up. What is the citation, please, for the Underwood judgment, which I've referred? It's Underwood and Bounty, 2022, EWHC 888, and it was in the Queen's Bench. So that reference again, this year, 2022, EWHC 888, so you should be able to find it on Bailey. Another question that's come in: when is the UT case you referred to going to take place? It would be so interesting to check that judgment, or maybe. The answer is it's in the back end of next month. The exact date I'm going to tell you in a second. Again, so I look at my calendar actually. No, it's not next month. It's 13th and 14th of July in the upper tribunal, at a course of 2 days. That's the answer to that. And other than that, let me just double check. I don't have any questions coming up on screen. I've answered all of the questions in my spreadsheet. If there's anything else anyone would like to ask, please do so now. But other than that, thank you for listening. Thank you for attending. And I hope you found it useful. Hand up. I think that's it. No, nothing further has come in. Oops, chat. Thank you very much, everyone.